All right, y'all. This PowerPoint is going to be about competence to refuse an insanity defense. So without further ado, let's jump on in. What is an insanity defense? The insanity defense is a plea of not guilty by reason of insanity. It's considered an affirmation defense, meaning the defendant admits to committing the act, but also argues they should not be held criminally or legally responsible. The key point is that the defendant must have been legally insane at the time the crime was committed. Competency. When a defendant refuses an insanity defense, the court has to decide if they are competent to make that choice. First, the defendant must understand the consequences, meaning the defendant must realize that refusing the insanity defense could likely increase their chances of a conviction and furthermore prison time. Second, the decision must be made knowingly. The defendant has to be aware of what they're giving up and what alternatives do exist. Third, the decision must be made voluntarily. The defendant can't make this decision as a result of pressure, coercion, misunderstanding, confusion, etc. This standard comes from the case Frendick versus United States that was heard in 1979. The court requires the judges to check that any refusal of an insanity defense is truly informed and voluntarily being accepted. Competency to refuse an insanity defense. The right to make decisions in your own case comes from a court case known as Ferretta versus California, which was heard in 1975. This court case emphasized individual autonomy, but in the case Frendick versus United States in 1979, the court ruled that a judge cannot enforce an insanity defense on a competent defendant. That case created what's called the Frendick inquiry, where the judge checks that the refusal is known knowingly and voluntarily. Can the court override the defendant's refusal of an insanity defense? A court cannot override a defendant's refusal if the defendant is deemed to be competent. However, if the refusal is not informed or voluntary, as previously mentioned, then the court can step in. So the balance here is between respecting an individual's autonomy and also protecting the fairness of the justice system. Why would someone refuse an insanity defense? A defendant might refuse this defense for many reasons. Some fear that they'll spend a longer confinement period in a mental hospital compared to a prison. Others are afraid of worse treatment in psychiatric facilities. Some defendants wish to avoid the stigma that surrounds mental illness. Other defendants fear losing rights, such as obtaining driver's license, or other defendants may view their crime as justified, like a political or religious act, and they don't want to label themselves insane. Can a defendant refuse this insanity defense? Yes, but it has its limits. As previously mentioned, a lot of the court cases are really focused on protecting civilians and individuals, their autonomy, right? Their choice to make their own decisions. On the other side, there is some duty to protect justice and ensure that the defendant does have a fair trial, that the defendant is being given a defense that for lack of a better word or term, can stand a chance in court. That's why competency has to be determined before a refusal is accepted by a judge. And the forensic inquiry helps courts strike that balance. And competency is typically determined by a forensic psychologist, and when mental illness and such is involved, a psychiatrist may also be involved as well. This slide I put together because I feel that it's really important to kind of see the timeline of all the relevant case laws that deal with competency. So bear with me here. I know there's 6 court cases here. There's several important cases that shaped competency, right? So Whalum versus United States was heard in 1965. This court case allowed courts to raise insanity defenses on their own. The North Carolina case versus Alford in 1970 allowed a defendant to plead guilty even while claiming innocence. Freda versus California was heard in 1975, and it established the right to self-representation. United States versus Marble was heard in 1978, further classified insanity plea issues. It was a really monumental case. Frendick versus United States in 1979 was obviously another monumental case, and one of the latter ones, which gave us the rule about competency refusals. And Indiana versus Edwards is the most recent case, which was heard in 2008 and further limited self-representation. And it noted in the decision making of this case, the wording was severe mental illness. And nowhere in my research could I find what the definition of severe mental illness was defined to be, and that furthermore makes it more discretionary for the judges in making that competency decision or the right to refuse the insanity defense by the defendant, which kind of leads us into the discussion question that I have created for everyone. The discussion question that I came up with is, should courts allow a defendant with severe mental illness to refuse an insanity defense even if the refusal increases their likelihood of conviction? Which I think is a really interesting topic. These are my references, the court cases, and the textbook. Thank y'all for coming.